Get ready for the dictation. Dictation will start in 5 seconds. Start. In this case, the majority was of the opinion that the cases of Sajjan Singh and Shankari Prasad were erroneous decisions, as they gave precedence to the amending power of Parliament over fundamental rights. Fundamental rights cannot be abridged or taken away by way of amendments to Article 368. Article 368 was subject to judicial review, and the word law under Article 13(2) includes an amendment, and any amendment violating the fundamental rights would be void. Although the definition of law in Article 13(3)(c) does not expressly mention amendments in a wider sense, it is included in it. Hence, Parliament has no power to amend any provisions of Part 3 of the Constitution. The Constitution, First Amendment Act 1951, amended various constitutional provisions including Article 14 and Article 19, and also inserted Article 31A and Article 31B with retrospective effect. The major objects behind this amendment are to provide for the acquisition of zamindari lands and the abolition of permanent settlement without any aid from the court. This amendment came as a consequence of various court judgments, like the case of Kameswar Singh versus State of Bihar 1952, where the Bihar Land Reforms Act 1950 was held to be unconstitutional. Various appeals were filed before the Supreme Court in regard to the constitutionality of this act, but before these appeals could be heard, this amendment was passed by the government. After this, the constitutionality of this amendment has been challenged before the Supreme Court in the case of Sri Shankari Prasad Dev versus Union of India 1951, where it was held totally valid. There were various grounds for contention, but the primary ground was that the amendments made under Article 368 of the Constitution were liable to be tested under Article 13(2). But the court rejected this contention and held that there was a clear demarcation between ordinary law made in the exercise of legislative power and constitutional law made in the exercise of constituent power, and in the context of Article 13, law must be taken to mean rules or regulations made in the exercise of ordinary legislative power, and not amendments to the Constitution made in the exercise of constituent power. In consequence, Article 13(2) did not affect amendments made under Article 368. But in the Golaknath case, the majority was of the opinion that this case was wrongly decided. The Constitution 17th Amendment Act 1964 amended Article 31A and extended the definition of estate to include Rayyatwadi and agricultural lands. Moreover, the ninth schedule was also amended by inserting two more acts, that is, the Mysore Land Reforms Act 1961 and the Punjab Security of Land Tenures Act 1953. This amendment saved the two acts from being declared unconstitutional on the grounds that they are inconsistent with the fundamental rights, Articles 13, 14 or 31 provided under Part 3 of the Constitution. The validity of this Amendment Act was challenged in the case of Sajjan Singh versus State of Rajasthan 1965 and was held to be valid. The court in this case has declared that Parliament had the power to amend fundamental rights. Stop.